is missed. Kouri Richins was convicted unanimously and beyond a reasonable doubt of attempting to murder Eric Richins, her husband, and the father of their 3 children. And then, having failed in her first effort of spending the next 17 days, not changing course, but doubling down, preparing to try again. And for what? Money. All for pecuniary gain. A person convicted of those things is simply too dangerous to ever be free.
7 words. That is all it took. After hours of testimony, after the children's statements that made the courtroom go silent, after 40 minutes of Kouri Richins standing in handcuffs telling her sons she is coming home, after all of it, Judge Richard Mrazik leaned forward and said 7 words, simply too dangerous to ever be free. Life in prison, no hearing, no review, no possibility of release. For the rest of her natural life, Kouri Richins will be inside the Utah State Prison, growing old in a cell in the same state where she made a Moscow Mule for her husband, watched him drink it, tucked a child into bed, and let him die. Now, before we go any further, I need you to understand something about this case that the coverage has consistently missed. The sentence is not the story. The sentence is the ending. The story is what Kouri Richins did to get there. The drug she asked for by a dead celebrity's name. The hospital she refused to take her husband to after the first time she poisoned him, and why. The letter she wrote from jail that prosecutors called evidence of witness tampering. The text she sent 3 days after her husband was found dead, asking her drug supplier if they still had a hookup. And the 3 little boys who stood in that courtroom and told a judge they feel safer with their mother locked away forever. That is the story, and it starts right now. On May 13, 2026, what would have been her husband Eric's 44th birthday, Judge Richard Mrazik looked across the courtroom at Kouri Richins and said 7 words that will define the rest of her life. Simply too dangerous to ever be free. Life in prison, no hearing, no review, no possibility of release. For the rest of her natural life, Kouri Richins will be inside the Utah State Prison. To understand where Kouri Richins is going and what she is facing, you first have to understand precisely what she was convicted of doing. Because the crime is not just the headline. The crime is a sequence of calculated decisions made over a period of months that the jury of 8 people in Summit County, Utah studied for 13 days before reaching their verdict in less than 3 hours. Eric Richins was 39 years old when he died. He was found unresponsive in his bed in the early morning hours of March 4, 2022 at the family home in Kamas, Utah, a small community near Park City in the mountains east of Salt Lake City. First responders arrived and declared him dead at the scene. An autopsy revealed that he had approximately 5 times the lethal dose of fentanyl in his system. He had no known history of drug abuse. No drug paraphernalia was found in the home. The medical examiner's findings made one thing plain. This was not an accidental overdose. Kouri Richins told police she had made her husband a Moscow Mule that evening to celebrate a successful real estate transaction, the pending purchase of a $2 million mansion she had been pushing him to buy despite their significant financial difficulties. She said she later went to sleep in one of their son's rooms because the boy was having nightmares. She said she returned to the master bedroom around 3 a.m. and found Eric cold and unresponsive. She called 911. Within hours of Eric's death, before his body had even been removed from the home, Kouri Richins signed papers to finalize the purchase of that $2 million mansion. That detail, signing a real estate contract within hours of calling 911 to report finding her husband dead, was one of the first things that drew investigators' attention. It would not be the last. The prosecution built their case around a pattern of financial desperation and calculated planning. Kouri Richins was a real estate agent with a house flipping business that was drowning in debt, millions of dollars of it. She was also in a long-term extramarital affair with a man named Robert Josh Grossman, who testified at trial about the relationship and about the guilt and sorrow he felt in the aftermath of Eric's death. The prosecution argued that Kouri wanted out of her marriage, wanted Eric's money. She believed she would inherit an estate valued at over $4 million, but did not want a divorce that would expose her financial misconduct or cost her the assets she had been misappropriating. So, instead, prosecutors said, she decided to kill him. But not just once. That is the detail that made this case what it became. The jury convicted Kouri Richins not only of Eric's murder on March 4, 2022, they convicted her of attempted aggravated murder for what prosecutors argued was a first, failed attempt to kill him on Valentine's Day 2022, exactly 2 weeks before his death. On February 14, 2022, Eric called 2 of his friends and told him he felt like he was going to die after eating a sandwich his wife had given him. He broke out in hives, couldn't breathe properly. The reaction was serious enough that he used the EpiPen that belonged to one of his sons, a child who might have a legitimate medical need for that medication, now being used by an adult male who was reacting violently to something in the food his wife had prepared. The question that investigators and Eric's family later raised was why, despite the severity of that reaction, Kouri Richins did not take Eric to the hospital. An adult male experiencing anaphylactic shock severe enough to require epinephrine is a medical emergency. The standard response is immediate hospital care. You call 911 or you drive. You do not wait and see. Kouri Richins did not take him to a hospital. Eric fell into a deep sleep. He survived the night, and Kouri did not seek any medical follow-up. Prosecutors argued the reason was straightforward and chilling. A hospital visit would have produced a medical record. That record would have documented the nature of the reaction, what substance might have triggered it, and the timeline. If there was fentanyl in that sandwich, and the jury determined there was, convicting her of attempted aggravated murder for this incident, a hospital visit would have created exactly the kind of documentary evidence that could connect her to the attempt. No hospital visit meant no record meant no connection. There's also the matter of the EpiPen itself. The EpiPen that Eric used that night was prescribed for one of his sons, a child who might have a legitimate medical need for that medication. The detail that an adult's potential poisoning was treated with a child's emergency allergy medication and that the adult was then left to sleep it off rather than being taken to a doctor is one of the elements of this case that Eric's family has pointed to as evidence of how completely Kouri Richins was willing to prioritize her own protection over the well-being of everyone around her, including her own children. The prosecution used this incident not just as a standalone attempted murder charge, but as evidence of a methodical, escalating pattern. The Valentine's Day attempt failed. Eric survived, so she tried again, and the next time she made sure the dose was lethal. Prosecutor Brad Bloodworth said in sentencing arguments that Kouri Richins doubling down after a failed first attempt showed not just intent, but a level of cold deliberation that made her uniquely dangerous. The judge agreed. When Judge Mrazik delivered his sentence, he specifically referenced this sequence, the attempted murder and then the murder, as central to his decision. A person convicted of trying to kill their spouse, failing and then successfully killing them weeks later is not someone the sentencing guidelines envision returning to society. That sequence is what drove the most severe sentence available. The phrase that has defined the drug evidence in this case, and that prosecutors return to again and again as evidence of Kouri Richins' specific intent, is not a legal term. It is not a forensic finding. It is 2 words that came out of a text message and out of testimony, and they are the words Kouri Richins used to describe what she wanted: the Michael Jackson drug. This phrase entered the trial testimony through Carmen Lauber, the family's former housekeeper who became the prosecution's most important witness. Lauber testified that when Kouri Richins asked her to obtain drugs through a street contact, she initially asked for pain pills for an investor she knew. After the first batch was not strong enough for the investor's needs, she asked for something stronger. After the second batch, she asked again for something stronger, and this time, according to Lauber's testimony, she referenced what she wanted as the Michael Jackson drug. In street parlance and in the context of Michael Jackson's death in 2009, the Michael Jackson drug refers to propofol, a powerful surgical anesthetic capable of causing rapid unconsciousness and, in uncontrolled doses, death. The source Lauber was working with told her he could not get propofol, but could get fentanyl. Kouri Richins, when informed the pills would be fentanyl, responded, "Okay, go ahead and get them." This exchange is significant for multiple reasons. First, it establishes that Kouri Richins was not passively acquiring pain medication for personal use or for some ambiguous investor. She was specifically asking for a substance capable of causing fatal sedation and escalating the request when the drugs provided were not potent enough. Second, the phrase itself, the Michael Jackson drug, demonstrates a level of awareness about the lethal potential of the substance she was seeking that undercuts any defense claim of innocent intent. The logistics of how the drugs were obtained and stored are equally revealing. Lauber testified that on at least one occasion, Kouri Richins left cash for her in the fire pit of a property she owned in Midway, Utah, one of the houses she was flipping for her real estate business. Lauber would collect the money from the fire pit, travel to meet the drug source at a gas station in Draper, and then bring the pills back to Kouri. The payment trail was disguised. One check written to Lauber for $1,300 was made out for Construction Clean Midway. As Lauber testified, "I never cleaned a house in my life for $1,300. The defense attacked Lauber's credibility relentlessly. They pointed to her history of drug use. She tested positive for methamphetamine in late January, mid-February, and early March 2022, the precise period in which the drug transactions were allegedly occurring. They highlighted inconsistencies in her prior statements, including that she initially told investigators Kouri had asked for oxycodone, not fentanyl. They argued that investigators had coached her responses, playing a taped interview in which an officer defined help as "give us the details that will ensure Kouri gets convicted of murder." They also noted that the man Lauber said she bought fentanyl from, Robert Crozier, recanted his corroborating story weeks before trial and told investigators he had sold her OxyContin, not fentanyl. The jury heard all of this. They deliberated for under 3 hours. They convicted on all counts. The circumstantial evidence, the phone searches, the cell location data, the financial motive, the timeline of purchases relative to the poisoning attempts, the text asking, "Still have your hookup," 3 days after her husband's death, was enough. The Michael Jackson drug phrase was enough. The sequence of escalating requests was enough. After the verdict, prosecutors described the totality of the drug evidence as demonstrating that Kouri Richins wanted Eric not only dead, but good and dead. 5 times the lethal dose of fentanyl in his system is not an accident. It is not miscalculation. It is a certainty. And it was achieved through a supply chain that Kouri Richins personally organized, funded, and directed over a period of weeks. May 13, 2026. The sentencing hearing for Kouri Richins began in the 3rd District Court in Park City, Utah, and ran for hours before Judge Richard Mrazik delivered his decision. By the time it was over, everyone in that courtroom had been through something emotionally exhausting. The impact statements from Eric's family, the statements from the children, Kouri Richins' own nearly 40-minute address to her sons, and the final arguments from both sides about what the rest of her life should look like. Judge Mrazik was not walking into that hearing without options. Under Utah law, the aggravated murder conviction carried 2 possible sentences. The first was 25 years to life, meaning she would eventually be eligible for a parole hearing, and the Utah Board of Parole and Pardons could theoretically release her if it determined by clear and convincing evidence that she is permanently incapable of being a threat to society. The second is life without possibility of parole, which means she dies in prison no matter what. Judge Mrazik said explicitly that he had considered both. He acknowledged the difficulty of predicting the long-term impact of either sentence on the 3 boys. He acknowledged the children's feelings today, their fear, their anger, their desire to see their mother locked away forever, might not represent how they feel in 10 or 20 years. He acknowledged the defense's argument that a life without parole sentence removes the possibility of any future reconciliation. And then he said what drove his decision anyway. He said the sequence of acts was determinative. Kouri Richins was convicted of trying to kill her husband on Valentine's Day. He survived. She tried again. She succeeded. That is not a crime of passion. That is not a single catastrophic decision. That is a pattern, a deliberate, escalating pattern of homicidal intent against a specific target, carried out over a period of weeks, in the presence of children, for financial gain. A person who tries to kill their spouse, fails, and then tries again and succeeds has demonstrated something about their character and their capacity that, in the judge's assessment, places them outside the range of people who should ever again live freely among others. He imposed the following sentences: life without possibility of parole for aggravated murder, 5 years to life for attempted aggravated murder, 1 to 15 years for each of the 2 insurance fraud counts, and up to 5 years for forgery. All of the sentences on counts 2 through 5 run consecutively to each other. No fines were imposed on any count. Judge Mrazik also noted something that her defense had argued, that the Utah Board of Parole and Pardons retains the theoretical authority to release even a life without parole inmate if it determines by clear and convincing evidence that the person is permanently incapable of posing a threat. In practice, this standard is almost never met for violent offenders convicted of premeditated murder. Deputy Summit County Attorney Brad Bloodworth had asked for exactly this outcome. He said in his sentencing argument, such a person should never again lurk among us. Her children should never worry that they may one day encounter her. The judge did not use those words, but he reached the same conclusion through a different path: the logic of the crime itself, the sequence of acts, the presence of children throughout, and the financial motive that drove it all. He delivered that sentence on what would have been Eric Richins' 44th birthday. For anyone trying to understand the full legal picture of where Kouri Richins stands as of May 13, 2026, here are the key takeaways from the sentencing: factual, specific, and verified from court records and reporting. Takeaway 1. She will never be eligible for parole on the murder charge. The judge chose life without possibility of parole over the alternative of 25 years to life. This is the most severe sentence available under Utah law for aggravated murder. The Utah Board of Parole and Pardons does theoretically retain authority to release any inmate, but the standard for doing so in a life without parole case requires clear and convincing evidence that the person is permanently incapable of posing a threat. In practice, this standard is almost never met for violent offenders convicted of premeditated murder. Takeaway 2. The additional sentences will add to her effective prison time, even though she will never leave prison. The sentences on the attempted murder, insurance fraud, and forgery counts run consecutively to each other, meaning they stack on top of one another. While this has no practical effect on the murder sentence itself, it means that even in the theoretically impossible scenario where the murder sentence were somehow revisited, she would still be facing decades of additional consecutive time. Takeaway 3. She faces a separate criminal case that has not yet gone to trial. On top of the 5 convictions from the murder trial, Kouri Richins faces more than 26 additional criminal charges in a separate case that includes mortgage fraud, money laundering, and the issuance of bad checks. Prosecutors allege she submitted falsified bank statements in support of mortgage loan applications for her real estate business. She has not yet entered a plea to those charges. When and if that case goes to trial, she will face it from inside the Utah State Prison, and any convictions will add further consecutive sentences to what she is already serving. Takeaways 4. She was also ordered to pay restitution. Prosecutors asked the court to order Kouri Richins to pay restitution to 2 insurance companies, totaling more than $1.3 million. This stems from the fraudulent life insurance policy she took out on Eric's life, using his forged signature, and the subsequent insurance claim she filed after his death. Takeaway 5. Her appeal window is 30 days. Defense attorneys can file a notice of appeal within 30 days of the sentencing. Kouri Richins said explicitly in her courtroom statement that she intends to fight the conviction. She said she would appeal no matter how long it takes. The grounds of any appeal have not been specified, but the defense spent considerable effort during trial challenging the reliability of Carmen Lauber's testimony and the coaching allegations against investigators, both of which could form the basis of appellate arguments. Takeaway 6. Her children's custody situation is resolved. A juvenile court ruled in November 2024 to grant custody of Eric's 3 boys to his sister Kouri Richins Benson and his husband Clint. This arrangement was already in place before the murder trial and is separate from. In the hours before Judge Mrazik delivered his sentence, the courtroom heard something that no amount of legal argument or forensic testimony could fully prepare it for. 3 therapists stood up, one by one, and read the victim impact statements of Kouri and Eric Richins' 3 sons. The boys were 9, 7, and 5 years old when their father was killed. They are now 13, 11, and somewhere around 8 or 9. Each of them decided individually how their statement would be delivered, through a therapist rather than in person. Each of them knew their mother would be in the courtroom when their words were read. 2 of the 3 boys did not call her mom in their statements. They called her Kouri. The oldest son, identified in court documents only by his initials CR, is now 13. He told the court that he did not miss his mother. He said his father was a good person, thoughtful, kind, someone who helped whoever needed help. He said he was afraid that if Kouri were released from prison, she would come after him and his brothers. He said, "I think she would come and take us and not do good things to us, like hurt us." He said he missed his dad. He said he did not miss how his life used to be. He said, "I don't miss Kouri, I will tell you that." The oldest son also described what life was like inside that house. He said his mother was always drunk or gone. He said she would frequently lock him in his room. He wrote, "Kouri would lock me up if I told her she was drunk." Prosecutors said that Utah's Division of Child and Family Services supported a finding of emotional and physical abuse against this child following Eric's death. These findings were contained in sealed court documents. The defense disputed them, arguing the initial DCFS finding was being misrepresented, but the oldest son's own words, written by a 13-year-old who was 9 when his father was killed, told the court directly what he experienced inside his own home. The middle child, AR, now 11, was described by prosecutors as a material witness to the murder. This is because Kouri Richins told police she had gone to sleep in his bedroom on the night Eric died, which was her explanation for how she did not witness her husband's death. AR told investigators and confirmed in his statement that her mother did not sleep in his bedroom that night. She was not there. Her alibi was his bedroom. He was in that bedroom, and he said she was not. In his statement, he told his mother, "You took away my dad for no reason other than greed, and you only cared about yourself and your stupid boyfriends." He said she was not caring and watching over him and his brothers. He described having to be a parent to his younger brother because his mother did not supervise them, walking the youngest to the bus stop, feeding him. He said he made him anxious about sitting on his father's side of the bed, warning him that he might die too if he sat there. He said, "I don't want you out of jail because I will not feel safe." He also said he has never heard her say sorry for anything she did to him and his brothers. He don't want her to hurt anyone again. The youngest son, WR, said he wanted her to go to jail forever. He said if she gets out, he would be so scared, really mad, and he would not want to go with her anywhere. He said she makes him feel hateful and ashamed when people talk about her because she took away his dad. He said, "Once she's gone, I will feel happy, and I will feel safe and relaxed and trust people more." Also read into the record were statements from Eric's family. His father, Gene Richins, described his son as a light to his boys, to the boys he coached, and to their entire community. He said Eric's soccer team still breaks the huddle chanting 1, 2, 3, Eric. His sister, Kouri Richins, Benson, who now cares for the boys, told the judge there is nothing Kouri will not do and no one she will not hurt to achieve her own selfish ends. She said the 3 boys were not bargaining chips, not cash cows, not props for some twisted children's book about grief and loss, and yet that is what they had been reduced to. Kouri Richins sat in handcuffs throughout all of this. When it was her turn to speak, she addressed her sons directly for nearly 40 minutes. She told them she loved them. She told them she did not kill their father. She told them she was coming home, not today, not this year, but one day. She told them to be like their dad. She told them never to apologize for something they did not do. And then the judge gave her a sentence that means she will never come home. Kouri Richins has been held at the Summit County Jail in Park City since her arrest in May 2023. That's where she spent the last 3 years, not a state prison facility, but a county detention center designed for shorter-term custody pending trial. As of May 13, 2026, she is being committed to the Utah State Prison. The Utah State Prison is located in Salt Lake City, Utah. The facility houses both the male and female prison population in Utah, with the women's unit operating as a separate section of the overall complex. Women convicted of serious felonies in Utah serve their sentences at this facility. There is no separate maximum security women's facility. All female inmates convicted of anything from minor felonies to capital crimes are housed within the same broader institution, with different levels of supervision and restriction applied based on the nature of the conviction and the inmate's behavior inside. For someone convicted of aggravated murder and serving life without parole, the initial intake process at the Utah State Prison involves a classification assessment. Prison staff evaluate the nature of the conviction, the inmate's mental health status, her medical needs, her history of behavior in prior custody, and any security concerns. Based on that assessment, she is assigned to a housing unit appropriate to her classification level. Given the severity of her conviction and the public profile of her case, it is likely she will be classified at a higher security level than the general population, at least initially. What daily life looks like inside that unit is a significant departure from anything Kouri Richins has experienced. She was a real estate agent, a house flipper, a woman who drove herself to business meetings and promoted a children's book on local television. The Utah State Prison operates on a fixed schedule. Wake time is typically around 5:30 or 6 a.m. Meals happen at set times in a communal dining area or are delivered to the housing unit depending on classification. Recreation time, outdoor or gymnasium access, is limited and scheduled. Movement within the facility requires escort or authorization. Personal property is strictly restricted. Contact with the outside world, phone calls, mail, visits, is monitored and limited. Work assignments are part of the daily structure for most inmates. The Utah State Prison operates prison industries programs and various internal work assignments. Given that Kouri Richins has a real estate and business background, she may eventually be assigned to administrative or clerical roles inside the facility, but this depends on her behavior, her classification, and the available assignments. Nothing about her prior professional life guarantees her preferential treatment. The question your title asks, can she survive prison life, is not a trivial one. Life without parole is a sentence that removes the psychological anchor of a release date. Inmates serving determinate sentences, 10 years, 25 years, know when they're getting out. They can count the days. They can plan around a horizon. Kouri Richins has no horizon. The Utah State Prison is where she will grow old. It is where she will receive whatever medical care the prison system provides as her health declines. It is where she will eventually die. The psychological weight of that reality is something that criminologists and prison psychologists document extensively. Inmates serving life without parole experience significantly higher rates of depression, anxiety, and adjustment disorders than the general prison population. Some adapt, finding community inside, finding purpose in education programs or religious practice, or mentoring other inmates. Some do not. The Utah prison system offers access to mental health services, substance abuse programming, educational programming, and religious services. Whether Kouri Richins engages with any of those resources and how she manages the cognitive reality of permanent incarceration is something that will play out over years and decades. She will not be near Park City. She will not be near the house she signed papers to buy hours after her husband's death. She will not be near her children, who have made clear, in writing, in open court, that they don't want her near them. The $2 million mansion, the house flipping business, the affair, the children's book, the television appearances, all of it is behind her. What is in front of her is a cell, a schedule, and the rest of her natural life. The sentencing on May 13, 2026 was not the end of the Kouri Richins legal story. It was the end of one chapter. Several others are still open, and the audience following this case needs to understand exactly what is still coming. The appeal. Kouri Richins said in open court that she intends to fight her conviction.
She said she will fight no matter how long it takes. Her defense team has 30 days from the sentencing date to file a notice of appeal. In Utah, direct appeals from a murder conviction go to the Utah Court of Appeals and from there can proceed to the Utah State Supreme Court. Any appeal would likely challenge specific evidentiary rulings, most probably the admission of Carmen Lauber's testimony, the coaching allegations against investigators, and potentially the scope of the financial crimes evidence admitted at trial. Appeals of murder convictions are slow. It is not unusual for the appellate process to take 2 to 5 years. During that time, Kouri Richins sits in the Utah State Prison. The separate criminal case. On top of everything from the murder trial, Kouri Richins faces more than 26 additional criminal charges in a case that has not yet gone to trial. These charges include mortgage fraud, money laundering, and the issuance of bad checks. The charging document in that case alleges she submitted falsified bank statements in support of mortgage loan applications and murdered her husband for financial gain as she stood on the precipice of total financial collapse. She has not entered a plea to these charges. The case will eventually go to trial,
or she will plea from inside the Utah State Prison, and any additional convictions will add consecutive time to what she is already serving. Civil litigation. Kouri Richins is also litigating property issues with Eric's family in civil court. The details of those proceedings are not fully public, but they involve the assets of the estate that she believed she would inherit, the assets whose anticipated value formed part of the financial motive the prosecution presented at trial. The civil and criminal proceedings are separate, but the outcomes of the criminal case inform the civil ones significantly. The children's future. The 3 boys are now living with Eric's sister and brother-in-law, Katie and Clint Benson, under the custody arrangement that a juvenile court approved in November 2024. Kouri Richins Benson has said publicly that she intends to speak more about the case following sentencing. The boys are in therapy. They are growing up in the care of people who loved their father. They will navigate the weight of this story for the rest of their lives. The public nature of the trial, the existence of the children's book their mother published about their father's grief, the knowledge that their mother is in prison for killing him, and the words they each wrote for a courtroom that heard them. Eric Richins' legacy. His father Eugene described him as a light to the community. His soccer team still chants his name. The people who knew him have said consistently that he was a devoted, present, loving father, someone who coached his kids, showed up for his community, and did not deserve what happened to him in his own home on the night of March 4, 2022. The trial and sentencing have provided a measure of accountability. What they cannot provide is the thing that Eric Richins' family actually wanted: Eric back. There is a specific and important legal argument that the defense is likely to pursue on appeal, and it deserves serious examination, because it goes to the heart of the prosecution's case and raises genuine questions about how the evidence was assembled. The Carmen Lauber problem. Lauber was the prosecution's most important witness. She was also, by her own admission, a person with a history of drug abuse, inconsistent statements, and a significant incentive to testify in the way investigators wanted. During trial, the defense played a recorded interview in which an investigator defined help as "give us the details that will ensure Kouri gets convicted of murder." That is an extraordinarily damaging recording for a prosecution to have to explain in front of a jury. The fact that the jury convicted anyway does not mean the appellate courts will find it acceptable. Lauber's initial statements to investigators did not include fentanyl. She mentioned oxycodone. The story shifted to fentanyl in later interviews, after she received an immunity deal, and after investigators, by their own recorded admission, had explained to her what they needed from her testimony. The man she said sold her fentanyl recanted before trial. These are not small inconsistencies. On appeal, the defense will argue that the admission of Lauber's testimony, under these circumstances, denied Kouri Richins a fair trial. The financial crimes evidence. Prosecutors spent significant trial time on evidence of Kouri Richins' financial crimes, the mortgage fraud, the debt, the house-flipping business failures, to establish the motive for the murder. The defense argued this evidence was prejudicial and far exceeded what was necessary to establish motive. The appellate court will review whether the trial court erred in admitting this evidence and whether any such error was prejudicial to the outcome. The missing direct evidence. It's worth noting for the audience what the prosecution did not have. They had no witness who saw Kouri Richins put fentanyl in Eric's drink. They had no recording of the act. They had no physical evidence directly connecting her hands to the substance in his glass. The conviction was built entirely on circumstantial evidence, powerful, extensive, and ultimately convincing to the jury, but circumstantial. Appellate arguments on the sufficiency of evidence in circumstantial cases are well-established territory. Whether the specific combination of evidence here survives scrutiny at the appellate level is a question that will play out over the next several years. The walk the dog letter. Before trial, prosecutors revealed that while in custody, Kouri Richins had written a letter from jail coaching her mother and brother on what testimony to give, what the defense's narrative needed to establish, what connections needed to be made about Eric's alleged drug use while traveling abroad. The letter was used by prosecutors as evidence of consciousness of guilt and witness tampering. The defense called it something else. Regardless of how it was characterized at trial, that letter and the no-contact order that prosecutors sought as a result will also be part of the appellate landscape. The bottom line on the legal challenges? Kouri Richins is going to prison for life. That is the reality she walks into from the Summit County Courthouse. But the legal fight is not over. Appeals in Utah murder cases typically move slowly. She will be inside the Utah State Prison for years before the appellate process reaches any conclusion. And if the appellate courts find that a reversible error occurred in the admission of Lauber's testimony, in the financial crimes evidence, or in some other ruling, the case goes back for a new trial. That is the legal landscape as of today. This chapter exists because the children's statements deserve more than a summary. They are among the most powerful pieces of testimony in this entire case, not because they were legally determinative, but because they represent the final accounting of what life was like inside the Richins household from the perspective of the three people who lived it from the beginning. The oldest son, C.R., now 13, said the following things in his statement to the court. He said his father was a good person. He said he does not miss his mother. He said he is afraid she will come after him and his brothers if she is ever released. He said she was always drunk or gone when he was growing up. He said she locked him in his room when she told her she was drunk. He said he felt he had to take care of his brothers because she was not doing it. He said he misses his dad. He said he does not miss how his life used to be. He said he does not miss Kouri. The oldest son, A.R., now 11, was the child whose bedroom Kouri claimed to have slept in on the night of the murder. He said she was not there. He told his mother she took his dad away for no reason other than greed, and she only cared about herself and her boyfriends. He said she was not caring and not watching over him and his brothers. He described having to walk his youngest brother to the bus stop and feed him because their mother was not doing it. He said she made him afraid to sit on his father's side of the bed. He said he does not want her out of jail because he will not feel safe. He has never heard her say sorry for anything she did to him and his brothers. He said he does not want her to hurt anyone again. The oldest son, W.R., said he wants her to go to jail forever. He said if she gets out, he will be so scared and really mad. He said she makes him feel hateful and ashamed when people talk about her. He said she took away his dad. He said once she's gone, he will feel happy and safe and relaxed and able to trust people again. Kouri Richins' response to all of this was to address her sons for 40 minutes, tell them she loved them, tell them the conviction was a lie, tell them she was coming home, and ask them not to give up on her. The judge sentenced her to life without parole 40 minutes after she stopped speaking. What those boys said in that courtroom is the record of what happens when the person responsible for protecting children instead becomes the thing they need protection from. Their father is dead, their mother killed him, and every single one of them, at 9, at 11, at 13, found the words to say to a judge in a room full of people that they wanted her locked away. Not because they were coached, not because they were angry in a temporary way, but because they had lived inside that household and they knew what she was. She told them she was coming home. The judge told her she was not. The boys are with their aunt. They go to school. They grow up without their father and without their mother, and in both cases, that loss was caused by the same person. One of those losses is permanent and irreversible. The other has been made so by the sentencing of Judge Richard Mrazik on May 13, 2026. Kouri Richins walked into the Park City Courthouse on May 13, 2026 in a neon green jail shirt and handcuffs. She walked out of it committed to the Utah State Prison for the rest of her life. She told her sons she is coming home. She told them she would fight this for as long as it takes. She told them the conviction is a lie and she would never have taken their father from them. Her sons told a judge they are afraid of her. They told him they would feel safe and happy and able to trust people again once she was gone. Judge Richard Mrazik told her she is simply too dangerous to ever be free. Eric Richins was 39 years old when he died with 5 times the lethal dose of fentanyl in his system, found cold in his bed on March 4, 2022. His soccer team still chants his name when they break the huddle. His boys are growing up with his sister's family. His father spoke at the sentencing and said his son was a light to his community, a light taken too soon. The appeal is coming. The separate criminal case is still pending. The legal story is not finished. But the murder case, the thing that started all of this, has reached its conclusion. And Kouri Richins will spend every day of whatever remains of her life inside the Utah State Prison, knowing that the 3 children she called her sweet baby boys told a courtroom they feel safer without her in it. Subscribe so you are here for every development in this case as it unfolds, the appeal, the pending charges, the civil proceedings. Share this video if the full story deserves to be seen, and leave your thoughts in the comments. Eric Richins deserved better. So did his boys. And now, at least, a judge has said so in a way that cannot be undone.